All right, good morning, everyone, and welcome to this month's second Wednesday break with Foster Swift. My name is Mike Kassar. I'm a Foster Swift attorney in our firm's employer services and workers' comp defense practice groups. And for those of you who are new here, we host this webinar on the second Wednesday of each month. Usually it's at noon. We pushed it to 9 a.m. due to scheduling reasons today. And it's just a time where I get to interview other Foster Swift attorneys about important and relevant topics in the law. And today I'm going to be interviewing my colleague, Tony Delamonte. Tony's an attorney in our Southfield office, and his practice primarily consists of commercial litigation and handling all aspects of employment law issues. Tony received his undergraduate degree from the University of Michigan and his law degree from Wayne State. Tony's been with Foster Swift ever since. And today we have a really interesting topic, artificial intelligence, or AI, as I'll refer to it for ease of use today. Specifically, Tony's going to be talking about employers utilizing AI software in the hiring process. And just as some background, artificial intelligence sounds complex, and it is, but at its core, at its essence, it's really just developing a computer system or software of some type to perform some tasks that humans usually perform. For example, there's a host of software companies marketing their AI software that can help automate the hiring process, make it easier. We can think of things like screening a high volume amount of resumes, sourcing potential candidates, and scheduling interviews, for example. I'll get Tony to share his thoughts on what employers should be wary of from a legal perspective when using AI in the hiring process. So good morning, Tony.
Morning, Mike. Thanks for the intro. We've seen the rise of AI tools like ChatGPT in the last few months, and it seems like, every company is racing to develop their own derivative AI program. And many companies are starting to integrate AI into their business, different aspects of their business, including hiring and recruitment practices. And while AI has the great potential to increase efficiency and sort of optimize certain business practices, I'm going to be talking about some of the risks associated with using AI in hiring and recruitment.
Yeah, this is a really interesting topic because ChatGPT and derivative softwares, like you mentioned, are just dominating the news cycle. So in regard to AI in the hiring process, can you explain where employers could potentially run into some liability when using this type of software?
Yeah, so the EEOC, which enforces federal laws prohibiting employment discrimination, has basically told us where employers could run into trouble. And that's with regard to the ADA and Title VII. The EEOC recently released its strategic plan for the next 4 years. And one of the areas of key focus of the plan is the employer's use of artificial intelligence in hiring and recruitment. And so, just a month ago, the EEOC issued 2 formal guidance documents to help employers with regard to Title VII and the ADA. And basically, this is they're waving a flag, they're throwing up their hands saying, hey, this is what you need to be concerned about. They're telling you that this is where violations of the law can occur with regard to AI and AI-related tools and how to avoid them. So those are the 2 documents that I'm going to be focusing on today.
Yeah, I feel like the EEOC and the federal government generally really has its work cut out for them in keeping up with the pace of this technology. So you mentioned that the EEOC has already provided some guidance. Can you talk a little bit about that?
Yes. So the first guidance was with regard to Title VII. And Title VII is the federal law that prohibits employment discrimination. The EEOC basically issued this guidance to help employers determine if their tests and selection procedures and hiring tools are lawful for the purpose of a Title VII disparate impact analysis. And disparate impact under Title VII basically occurs when a neutral policy or practice, say, you're using a particular hiring software, has the effect of disproportionately excluding persons based on a protected status. So, there's 2 main takeaways from the EEOC's Title VII guidance. The first is that employers can't assume that the AI tools that they're using are non-discriminatory. The EEOC states in no uncertain terms that employers are the ones who are responsible for selection procedures developed by third-party software vendors. So That means that, if it is found that your particular software hiring tool that you're using has a disparate impact on certain protected status and certain minority groups, you could be the one that's on the hook. So employers need to be aware of, what hiring software they're using, what steps the software is taking to be non-discriminatory. To give you an example, if an AI tool automatically screens out applicants based on large gaps of employment, this could have a disparate impact on the basis of sex, as gaps in employment may be the result of pregnancy or leaving the workplace to raise children. And so, the big thing is that the EEOC encourages employers to be proactive and to analyze their employment practices, including the hiring software, on an ongoing basis to ensure that, there's no adverse impact. So that was the first main takeaway. And the second main takeaway is that the EEOC encourages employers to consider alternatives if AI tools do in fact cause a disparate impact. And the general rule of thumb that the EEOC uses is called the 4/5 rule. And under the 4/5 rule, a selection procedure could be found to have a disparate impact if the selection rate of a protected group is less than 80% or 4/5 of a non-protected group. And I'd be happy to discuss, how to go about this analysis on a deeper level if anyone is interested after the presentation. But that's the general rule that the EEOC uses. And if an employer finds that an AI tool is causing a disparate impact, the EEOC recommends that the employer should then determine if the tool is job related and consistent with business necessity. And employers may be, required to explore a less discriminatory alternative if one is available. And ultimately, an employer may be liable for failure to adopt a less discriminatory algorithm. So, I think the main takeaway is you need to be proactive in analyzing your own tools here.
Yeah, really take an active role as an employer in evaluating the software. Try to figure out what it's looking for from the company that's making the software. And if you feel like it could potentially, cause a disparate impact against some protected group, then you got to search for an alternative. That seems like it's the takeaway, right, Tony?
Yep, that's right.
Okay. So with this EEOC guidance, are they providing any sort of specific guidance for employers on how to avoid liability related to Title VII?
Yeah, so the EEOC says that at a minimum, you need to ask the vendor or whatever, third-party software company that you're using AI tools with, you need to ask them to evaluate and to explain what steps they have taken to ensure that the tool doesn't have a substantially lower selection rate for individuals with a protected characteristic under Title VII. And, the unfortunate thing is if the vendor is incorrect or they tell you, yes, we've, taken all the appropriate steps. If the vendor's incorrect and the tool does cause a disparate impact, unfortunately, the employer is the one who's on the hook. So again, employers need to be proactive in analyzing these hiring tools and, potentially do their own selection analysis.
Got it. So you just talked about the EEOC guidance related to Title VII, but you also mentioned before about that guidance being related to the ADA, the Americans with Disabilities Act. Can you talk about that?
Yeah, so the other guidance that the EEOC issued was with regard to the with regard to the ADA and employers' use when making decisions in hiring, monitoring, compensation, and other terms and conditions of employment. In the guidance, the EEOC identified 3 ways in which an employer, could violate the ADA. First is failure to provide a reasonable accommodation to an applicant or an employee who needs an accommodation to be fairly and accurately rated by the algorithm. So, for example, if an applicant, has to watch a video as part of a mandatory personality test, a visually impaired applicant should be given an accommodation that does not require watching that video. And an AI tool, won't be able to screen or recognize that. Second, if there's a risk of screening out an individual who has a disability, even though that person is able to perform the job with a reasonable accommodation, that's a big risk. And third, if the tool or the AI, makes disability related inquiries or medical examinations, the ADA would be violated. So the employer can't use an AI tool prior to making an offer of employment that could be used to identify a candidate's medical condition or ask any questions related to a disability, without violating the ADA.
Yeah, and in your opinion, and based on this EEOC guidance, are there any ways for employers to limit or avoid liability with regard to the ADA and using AI in the hiring process?
Yeah, I think one of the big things that the EEOC recommends is that employees and HR staff be trained to quickly identify and process a request for an accommodation. And the EEOC recommends that applicants be told in advance that reasonable accommodations are available and explain the process for requesting such accommodations. The EEOC explains that the employer should have alternate means available to rate an applicant if the applicant would be unfairly disadvantaged by use of a computer-based tool due to the applicant's disability. And from a practical perspective, you as the employer using a software company or a vendor, the EEOC advises employers, again, to ask questions and, make sure you understand as much as you can what you're purchasing and what you're implementing for your business. And at a minimum, the employer should have the vendor verify that you're not asking any questions about someone's, disability or any impairments or any medically related questions that could get you in trouble with the ADA. So again, the big thing is to be proactive and, ensure that you understand what you're implementing in your business.
Tony, I would also think that, in that process of trying to understand what you want to implement in terms of AI, company wants to document this too, right? Get it in writing from the software company, right? Don't we want companies, employers to document this sort of thing? If the EEOC does come after the company for whatever reason, we want to say, yeah, look at the employer was able to document this conversation. They've reached out to the software company, tried to gather all this information about potential discrimination in their software. Would that be good advice too?
Absolutely. I think documenting any communications that you have with the third-party vendor, unfortunately, the EEOC's guidance sort of indicates that you might be on the hook either way, but there might be ways to, explore potentially looping in the third-party vendor if they do, verify that its tools are non-discriminatory or, don't ask any questions that violate ADA. You might be able to enter into an indemnification agreement with the, third-party vendor where if they make all these representations to you about its tool and its non-discriminatory nature, and then you do get sued for discrimination, then they, may be on the hook for it. But, at the end of the day, I'm not a software engineer. You're not a software engineer. Most people aren't. And so as many questions as you ask about, the AI tool and the software, that only goes to a certain point. And so, an employer is limited in what they can do, but we're recommending to our clients that ask as many questions as you can, get it in writing, understand what, is going into the tool so that you can hopefully protect yourself.
Yeah, as an employer, being proactive is going to go a long way. Are there any other takeaways we want employers and some of our firm clients to know about this topic?
I think we've touched on about everything. I think AI provides a fantastic opportunity to become more efficient and to optimize certain aspects of your business. But again, it's just being proactive, monitoring your current systems and asking questions.
Tony, thanks so much for giving that information. If you guys have any questions, you can put them in the chat now or reach out to me or Tony afterward. Our information is available on Foster Swift's website. You can always email us or call us with any questions. We also have a team of employment lawyers here at Foster Swift, including Tony and a few others. that are handling issues like this all the time. We have Cliff Hammond, Mike Bloom, and Carl Buterer in Grand Rapids. So if you have any questions, reach out to any one of us. We'd be happy to help. We do this every month. We talk to a different member of our Foster Swift attorney team. And next month, we're going to be, what date is it? I think it's going to be the second week of July at noon. We're going to be going back to noon. We currently are working with, they're working on setting up another guest, and it's going to be another great topic. So we look forward to seeing you here. Otherwise, have a great morning, have a great day, and take care.